You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, welcome to another episode of the Max Planck Lawcast. Today we're going to be doing a deep dive into an ongoing economic saga that has blossomed into a full-blown legal battle between the US tech giant Apple, known for its iPhones and AirPods, the Republic of Ireland, known for Guinness and leprechauns, and the European Union, known for the Euro, the Schengen area, and of course, bureaucracy. This highly publicised case has seen the EU challenge Ireland's taxation policies and their agreement with Apple, with the EU arguing that the tech giant has paid significantly less in taxes than legally permissible. As we'll see, this tussle raises serious questions about federal solidarity, the role of large multinational corporations, and economic sovereignty, especially with regard to taxation. So whether you're a tax expert, a tech enthusiast, or just curious about global economic issues, join us today as we dissect the far-reaching implications of this dispute and what it means for the future of corporate taxation in Europe. Now, I'm not a tax expert, maybe an expert in paying taxes, but certainly not a tax expert, so I'm very pleased to announce today that I'm joined by Ruth Mason. Ruth is a distinguished professor on law and taxation at the University of Virginia School of Law, and moreover, Ruth is a Max Planck Law Fellow, and best of all, she's offered to come onto the program today and talk to me about the case at hand. Ruth, welcome to the Lawcast.
Thanks so much. I'm happy to be here.
Yeah, it's wonderful to have you on the show today. We've got a lot to talk about, so it may be a slightly longer podcast than usual, but that's all right. It's a very interesting topic and very topical, as we've seen, because there's a number of decisions have just come up recently, which you're going to tell us all about. So, I mean, as I say, we're going to be talking about this legal tussle today between Apple, the Republic of Ireland, I think, which we'll just refer to as Ireland from now on, and the EU. I certainly vaguely remember hearing about the case, I think back in 2015-16. What particularly gave me a chuckle at the time was that Ireland was refusing to lay claim to billions of euros in back taxes that the EU Commission had said that it was entitled to. And it seemed that such behaviour was almost unheard of from a country to withgo tax money. But I'm sure there's more to the case than this little tidbit, so maybe you can provide us with an overview for the listeners so we can really talk about this Apple Ireland EU tax case and kind of set the stage for the rest of our podcast.
Sure. So before we start and dig right into these cases, I want to make it clear that I'm a law professor. I am not a lawyer for the Commission or Ireland or Apple or any party to any of the recent tax cases involving state aid. I have no financial stake in any of these cases, although I do own Apple stock in my retirement account.
Okay.
So my interests are purely academic.
Certainly.
And with that out of the way, it all started, as you say, with Apple and Ireland. Apple, as everybody knows, is a U.S. headquartered tech company. What people don't know is that it established two subsidiaries with branches in Ireland. Okay, so there's nothing remarkable about that, but it turns out that Apple's financial engineers are no less clever than their software engineers, and Apple financial engineers took advantages of differences between US and Irish law in the formation of these subsidiaries. So under Irish law, Ireland would only tax a company on its global profit if it's managed and controlled in Ireland. And under US law, the United States only taxes a company on its global profit if it's incorporated in the United States. So by incorporating these two subsidiaries in Ireland, but managing and controlling them from the United States, Apple created stateless companies, taxable on their global income by no country on earth.
Oh.
Yeah, nice, right?
Yeah,
so,
that's right.
Like I said,
Yes,
the software engineers, they're right up there with the financial engineers.
Brushed up on the financial engineers, definitely.
So international tax lawyers call this tax arbitrage, when a single taxpayer takes advantage of differences between two states' laws to derive a tax advantage. So once Apple has these stateless subsidiaries as part of its overall tax plan, Apple shifts significant profits into these stateless companies. These profits were shifted both from the United States and from other parts of the world. And so a huge portion of Apple's global profit was earned, at least on paper, by these stateless companies taxed on their worldwide income by no country on earth. So the European Commission, which is in charge of enforcing Europe's anti-subsidy law, unsurprisingly had a major problem with the idea of all this Apple income being taxed nowhere. Several commission officials came out in the press and they said it just wasn't right that this income should be taxed nowhere, and they were going to do something about it. So what the commission ended up arguing was that Ireland allowed Apple to avoid Irish taxes and that this constituted an illegal subsidy under EU state aid rules. The challenge for the commission was to make out a viable case against Ireland. Okay, to do that, it had to show that rather than non-taxation resulting from mismatch or gaps between two different countries' laws, here the US and Ireland and Ireland alone was somehow responsible for letting Apple get away with avoiding tax on its global income.
Okay, so the case itself, introduced it as the Apple Ireland EU case. The case, though, was more between the EU and Ireland, and Apple was a third party, so to say.
Exactly. So all state aid cases go against the member state. It's the member state that violates EU law by providing the subsidy to the private person, in this case, Apple.
Right. Because for Apple, obviously, as you've said, they've got some clever financial engineers there. They've obviously looked at Ireland and they've seen it's a sovereign state within the EU, but a sovereign state. It has its own taxation policy. In its eyes, they were simply adhering to the laws of Ireland and that there was, on their part, no wrongdoing. Is this correct?
That's how Ireland saw it.
Mm-hmm.
So Ireland says, look, there's nothing in the EU law or EU treaties that requires Ireland to tax companies the same way the United States does. Ireland does not have to tax companies on the basis of incorporation like the US does. So Ireland just chose a different basis, management and control, than did the United States. So the laws don't match. So what? Of course, so what was that Apple could create these stateless companies and then shift all their profits to the stateless companies where they would be taxable neither by Ireland nor by the United States. But the Irish view, what Ireland argued with some justification, was this is not my fault, or at least it's not my fault alone. The problem arises from two different states' laws, and I, Ireland, can't be held responsible for the laws of the United States. And EU law doesn't require me to have exactly the same laws as the United States. There's a mismatch. And that argument turned out to pose quite a challenge for the commission, because to prove that a state conferred state aid, illegal state aid, in the form of tax savings, the commission has to show that the member state violated its own law to reduce the company's tax. So now the commission needs a legal tactic to try to get at this stateless income. So what the commission decided to argue was that all the income in these two stateless companies was, in truth, earned by two small branches that the stateless companies had in Ireland, and Ireland should have taxed all that income to these two little branches.
When you say all this income, this is from across the EU, the income that Apple's been making, or is it worldwide? Or
so it's all of Apple's income except the income from North and South America.
Oh, wow. Everything, almost a large chunk of the worldwide income went through these two small companies in Ireland.
That's the claim. That's the claim.
Okay.
That claim, as your reaction reveals, does not accord with economic reality.
Yes.
But that's the argument.
Okay. Mm-hmm. Understood.
And it derives from the fact that Apple put all the profits in these stateless companies on paper.
Mm-hmm.
Okay, so on its books, it says all this profit is in these stateless companies. Okay, so the branches are not that big. Apple does have activities, real activities in Ireland, but they're small relative to what's going on in the rest of the world. And all of Apple's most important employees work in the United States, not in Ireland. And the location of the employees, especially the managerial level employees, the R&D employees, is really important because under normal tax principles, income is allocated where the most important employees are. That's a big factor. Okay, so Ireland consistently argues throughout this case that under Irish law, the way to determine the profits of those little Irish branches is that you look just at what the Irish branches actually do.
What they're actually doing in Ireland, so to say.
In Ireland, yes. So you just look at what's happening in Ireland and you make sure that those real Irish activities are getting remunerated, they're generating income, and that income is going to be taxed by Ireland. So that's the Irish view. It just looks at the branch. The problem with this allocation rule from the Commission's perspective is that it doesn't draw into Ireland all of these stateless profits. Those profits weren't substantively connected to Ireland, but the Commission still wants to tax them. So again, it needs some way to get those into Ireland. And the legal theory it settles on is that Irish law required application of something called the arm's length principle, and that under this arm's length principle, the profits of the stateless companies should have always been allocated to the Irish branches.
Okay, I think you're going to have to tell me what the arm's length of a leprechaun is then.
Good. What is this arm's length principle? Okay, so it turns out that OECD countries, the Organization for Economic Cooperation and Development, sets a bunch of tax standards, and the members of the OECD have agreed on a set of optional guidelines for applying the provisions of tax treaties. And these guidelines instantiate something that the guidelines themselves call the arm's length standard. So there's this international standard out there that's meant to allocate income earned by a multinational group to its various entities and branches that are in different tax treaty partners around the world. So the idea is to help the treaty partners divide the profits of an integrated enterprise between the two states.
Okay, I understand. I think
Okay,
you did
so
a good
that's
job
where,
exactly breaking
yeah, so
that down.
that's where this arm's length idea doesn't come totally from the ether. It comes from the OECD, but the problem in Apple was that no tax treaty applied.
Why did no tax treaty then apply?
Because the companies were stateless.
Aha. Yes, I'm beginning to see how clever this was.
Right. So again, clever financial planners in Apple. So Ireland says no tax treaty applies. That means I apply my domestic allocation rules for determining the profits of the branch. And again, I'm back to just looking at what's going on in the branch and I remunerate that. So this, again, the Commission's in a bind because it has to argue that Ireland violated its own law by failing to apply this arm's length standard to Apple. So the first tactic the Commission chose was to argue that the arm's length standard applied to all EU member states as a matter of EU law, that it was an independent requirement under EU law, and that the arm's length standard applied as part of state aid law. And this argument, if it were to be believed, would allow the Commission to ignore member state domestic law in all of its tax ruling cases, and instead it could just apply this OECD arm's length standard in every case.
Yeah, that's right. Okay, because we're going to get back to that a little bit later with the, as you say, this what that would actually mean, the wider repercussions. But you're saying that the member states get to decide their taxes, and the Commission then, though, has to establish that there was state aid by reference to Irish law.
Yeah, so normally the way it works is the member states decide what their tax law is, and then the Commission has to say, no, you violated your own law and you let the company pay too little tax. But now, under this novel theory, the Commission says, no, your domestic law doesn't actually matter. What matters is this state aid arm's length standard. It applies as a matter of EU law, and you're bound to it, Ireland and all the other countries. But Ireland and Apple contested this, and the Commission ultimately ends up changing its argument. And so instead of saying that the arm's length standard applies as a matter of EU law, the Commission instead says Irish law itself requires the arm's length standard.
Oh, okay.
And because Irish law requires the arm's length standard, it was fine for the Commission to check Ireland's income allocation by reference to this arm's length standard. Okay. So It's a steep hill to climb to try and get all these paper profits into the Irish branches, and it forces the commission to make some of these really uncomfortable legal arguments. So first, the commission says, actually, Irish law requires the arm's length standard. And then it says, in determining what the arm's length standard means, we can look at this OECD guidance. Okay, so now that guidance is not part of Irish law.
Mm-hmm. And is only a guideline.
It's only optional.
Mm-hmm.
Okay, but the commission says that it can use the OECD guidance as a tool to check whether the Irish tax administration allocated the income to the branches properly. And then the commission takes one further step. It argues that this OECD standard, which goes by the name among tax aficionados, the AOA, the Authorized OECD Approach.
Okay.
AOA.
AOA, yep.
And so the OECD developed this standard for allocating income between a branch and its so-called head office, which is the part of the company that's not the branch. And so the one further step the commission takes is to argue that this AOA requires that the stateless company, shorn of its U.S. activities, has to be compared with the activities of the Irish branch. So you just compare the two, okay? But you don't look at the U.S.
Okay.
And then comparing this head office with, the commission argues, no U.S. activities to the Irish activities of the real Irish branches, the commission says, look, as between the two, all the activity is in the Irish branches. There's nothing going on in these head offices. And so you have to allocate all the income to the Irish branches.
Okay.
Okay, but this theory is dependent on the requirement that Ireland never should have looked at what was going on in the United States. So we ignore the United States.
Yes.
We compare only the head office to the Irish branches, and we say, well, there's more activity in the Irish branches than in the head offices, at least if we ignore what's going on in the US. So as between the two, the empty head office doing nothing, and the Irish branch doing, well, not much, but something, only one of these has substance, and so that it has to get all the profit.
I understand, yep.
So that's how the commission puts all of the Apple profits from outside North and South America into Cork, Ireland.
Mm-hmm. The actual branch, so to say, which suddenly became the most profitable branch of Apple then.
Absolutely.
At least in the commission's eyes.
And no one's more surprised, of course, than the employees in Cork, Ireland to learn that they are the genesis of tens and tens and tens of billions of dollars of profit for Apple worldwide. They will probably ask for a raise now.
That's right, absolutely. And Ireland's GDP just skyrocketed.
Okay, so there were at least two problems with the commission's application of this authorized OECD approach in the Apple case. Okay, so one is that this authorized OECD approach, the AOA, was invented 19 years after the first facts in the case arose. So the application was retroactive. And Ireland had not adopted this AOA even once it was invented. So the facts of the case begin in 1991. The AOA is invented in 2010. But even in 2010, Ireland didn't adopt it. It didn't adopt it till 2020, which was after all the facts in this case are completely finished. So that's one problem, retroactivity. The second problem is that the AOA does not actually require ignoring the U.S. activities of the stateless companies in allocating the income. And the simple reason for that is that ignoring substantive activities in the allocation of income would not produce an arm's length standard, which is the standard that the AOA is meaning to implement. So these OECD standards are all directed at understanding substance and trying to allocate income where value was actually created. Now, figuring out where value is created is no easy task, and governments and taxpayers often disagree about where value was created. But the OECD standards are designed by government administrators in part to help them combat corporate tax avoidance. So it's not really reasonable to assume that the standards would dictate ignoring the substance. And indeed, those standards, even if they applied in Apple's case, which Ireland and Apple always argued that they did not, could not have required Ireland to ignore the real activities of these stateless companies in the United States. On the contrary, if these stateless companies had U.S. branches, the AOA would have allocated income to those U.S. branches. And considering that the U.S. branches here did most of the important functions, the AOA would therefore award most of the income to the United States. Okay, so let's just contrast, right, what the Commission is arguing versus what Ireland and Apple are arguing. Ireland says, all my law requires is I look at the branch, I figure out what the branch really is doing, and I make sure that I tax the income from those activities. And then the Commission says, no, that's not the right allocation method. What you have to do is look at the whole stateless company, ignore anything it might be doing in the United States, and allocate as between the Irish branches and the head offices minus the U.S. activities, so Ireland gets everything. Some people might have argued that the Irish branch allocation rule, you just look at the branch, that's state aid. That is, that Ireland should have taken an approach that was wider in scope, but that's not what the Commission argued. Instead, the Commission argued that Irish law somehow required this AOA that wouldn't be invented for 20 years and that cut the United States out of the profit share entirely. So, what you end up with as a result of all these arguments is the rather strange outcome that a substantial portion of Apple's overall global profit ended up being allocated to Ireland, where there were only 6,000 employees, rather than to the United States, where there are tens of thousands of employees, including all the most important employees, such as the software engineers and the managers of the company. So you end up with this result that the income is assigned to Ireland where it does not belong substantively. But since the Commission couldn't make the United States tax the income, the Commission thought the only way to ensure that it wouldn't be stateless and wouldn't be not taxed anywhere was to force the income into Ireland.
Okay, so obviously the income that was going into Cork from the Cork branch or into Ireland from selling iPhones, from selling apps in the Irish App Store, and that was being taxed in Ireland. The issue, though, is all the other sales are going through these two stateless companies not being taxed anywhere. Are they being taxed in any way, shape or form in Ireland or not at all? They're not recognised by Ireland.
Ireland taxed what it said it was required to tax, which was the real activities of the branch. So then I've said, well, the rest of this profit belongs to the United States substantively.
Okay.
But that doesn't necessarily mean that the United States taxed it.
I see. Okay. And that's then, I guess, what we're getting to now is if the profit was going to be then taxed by the United States, if so, then I guess the Commission would have been fine with it being taxed. The question, though, is where was the Commission's main concern here, that the money would never be taxed at all?
Yeah, so far we've said that substantively the profits are American, so why isn't the United States taxing? Well, again, here you have to lay this at the foot of the financial engineers of Apple. When it made these stateless companies, these are separate legal entities. They are not resident in the United States. They're not resident in Ireland, but they're also not resident in the United States. And that means that under U.S. law that applied at that time, the U.S. couldn't reach those profits. And so that income wouldn't be taxed by the United States until it was distributed from those stateless companies back to Apple Inc. in the United States.
If they were to put it to work in the US to invest it or to pay dividends or whatnot, then it would be taxed once it was
Then it would be taxed.
Okay, right, okay.
But the payment of those dividends was 100% in the control of Apple. Apple could do that whenever it wanted or never.
Yep.
So what you end up with is tax on very little in these Irish branches and no current tax in the United States, and indefinite deferral because the only person who decides when Apple gets taxed on that is Apple.
It's Apple. Okay. Understood.
By the distribution. Okay, so that's how you get this outcome that the commission is unhappy with, which is Apple has enormous global profits that are not being currently taxed. And so that's why it gets to this odd theory, which is to try to put the income and move it from these stateless head offices into these Irish branches. But, the U.S. takes umbrage at what it sees as the commission's attempt to reach out and use state aid to assign to Ireland what is really income that ought to have been taxed by the United States. So the U.S. view is something like, well, we may not be taxing Apple's profits right now, but if you assign it to Ireland, there'll be nothing left for us to tax when Apple finally makes a distribution to the United States. And, that reasoning was because under U.S. law, if a company distributes income that's already been taxed by another country, the U.S. won't tax it a second time. So you end up, from a U.S. perspective, where either Ireland is going to tax or the U.S. was going to tax, but not both. And if anyone should tax, it should be the U.S. So the U.S. tries to intervene as a party in the case. And it says that the commission is invading U.S. tax entitlements. But the Court of Justice does not allow the United States to intervene on the grounds that the United States has no ripe legal claim because Apple hasn't distributed the profits yet.
Ah, I see. No ripe. The apple was not ripe enough for the...
That's exactly right, yes.
Okay, but we're not going to... The US is still involved. We're going to come back to them a little later on there. But let's stick with Ireland. And I'd like to know, I guess, going back to my anecdote at the start, they've got this windfall. They've been told 13 billion euros. The commission says, Ireland, you have to collect this money. And Ireland is like, no way, we don't want this money. Obviously, Ireland was somehow profiting from this deal as well with Apple. I mean, why was it so that Ireland, one, set up this kind of construct, and why did they not want the money at all?
Right. Who doesn't want $14 billion?
Yeah.
Why not take the money and run? Okay, so for Ireland, it was a point of principle. Ireland was defending its sovereign entitlement to define its tax base. Ireland explained that under its own law, the way it would assign profits to the Irish branch would be just to examine the activities that were actually happening in Ireland and make sure that those activities got the right amount of income that was taxed.
Mm-hmm.
So Ireland argues that, Apple is taxable to some extent on the activities that it actually conducts in Ireland, but it would be wrong under Irish law to attribute the activities that actually happen in the United States of America to Ireland and to assign to Ireland the income from those activities for tax. So Ireland argues that it doesn't have that power under its own law to tax anything other than the income that actually comes from Ireland.
Okay.
And it also didn't think that the Commission had the power under the Treaty on the Functioning of the European Union to order Ireland to tax profits that weren't Irish.
Mm-hmm.
So, Ireland was making an argument to declare that Ireland and Ireland alone decides what Irish tax law says. And it was also defending the work of its own tax administrators who had approved this ruling for Apple in what Ireland said was accordance with Irish law. And then, you asked, what's Ireland getting out of all of this?
Mm-hmm.
Why does it help with this structure? I think you can see it for a little country like Ireland. It doesn't want to introduce a significant element of uncertainty into its law because that uncertainty can scare off foreign investors. So Ireland adopted this one-sided branch profit allocation rule, this rule that says you just look at the branch because it wanted to attract inbound investment. That's a good taxpayer-favorable rule that helps, in the grand scheme, helps Apple with its overall tax plan, right? And Ireland wants to be able to use its tax sovereignty and its definition of taxable income to attract investment into Ireland.
I see what you mean, because often you hear about that Ireland is a bit of a foothold in Europe. Often it's an English-speaking country, as you say, stable legal system for international companies to step in if they want to set up in Europe.
And stability is key. Stability is key to foreign investment. Foreign investors need to know what the legal situation is in advance. And if the commission can come through decades later and change the member state's law and apply law that's different from what the state had on its book, that's going to chill investment not only into Ireland, but into other EU member states. But at the same time, you can also see why the commission wanted to go after this tax plan. Because Ireland does have this rule to try and help Apple, and Apple had engaged in aggressive tax planning. And if Apple can avoid its tax obligations, but other countries can't, then that's going to create a competitive advantage for Apple over other companies. So the commission, I think, is not wrong that there was state aid here. I think the commission was wrong about the form it took and the legal theory that it went about to try and claim those profits. Basically, the commission got too greedy in saying all of that profit should be in Ireland, because in order to make that argument, it has to stretch so far and depart so far from reality that basically nobody can accept the outcome of the case. And it just looks like the fix was it. Be that as it may, the commission sticks with this theory that's going to put all the profits into Ireland, and Apple and Ireland end up going to the lower EU court to complain about this commission theory.
How did the commission gets together and makes a decision then on how does that work exactly?
What is the commission? The commission is a one-of-a-kind type of institution. It's not elected. It's got the power to enforce state aid law. I mean, it's elected, but it's not popularly elected.
Okay, yes.
The members of the commission. And it's got the power to enforce state aid law. And so it has this mandate in the treaty that says if there is state aid out there, if there is illegal aid, then you, commission, must find it. And you sue the state that you investigate the state that you think is conferring the aid, in this case, Ireland. And if you find that state conferred state aid, then you, the commission, order the member state to recover the aid. So that's why ultimately Apple's on the hook.
Yes.
For
The
the payment.
on the hook. That's right. But the commission, the bone it's picking is with Ireland in that case. Yeah. But so obviously, I mean, we're talking about a saga here. So Ireland and Apple, they don't see eye to eye with the commission's decision here. And you just mentioned that they took it to the lower court?
Yeah, so the first place they have to go is the lower court. And Apple and Ireland asked the lower court to vacate the commission's recovery order on the grounds that the legal theory the commission used was wrong. Specifically, right, Ireland keeps arguing, you have to use Irish law. You can't use this OECD standard. You can't use this AOA, at least not if it's not part of Irish law, and it wasn't, right? The general court in Apple held that because Irish law was in some respects similar to this OECD standard, the commission was allowed to use the external standard instead of Irish law to determine whether Ireland assigned the right amount of Apple's income to Ireland. So in other words, the commission wins the legal issue in the general court, and it gets to apply this AOA.
Okay. Just a quick question. General court and the lower court, are they the same?
They're the same.
They're the same.
General
Okay.
court and the lower court.
And this is the lower court of the European Union.
Yes, the General Court of the European Union is the lower court. And I know why you're asking me this question, because you've heard that Apple won below.
Yes, that's right. That's what I've heard. Exactly.
Yes. So I just told you it lost in the law, and it did. But you heard it won, and that's also true. So it won on the facts.
Okay. The facts that?
The General Court concluded that the commission didn't bear its burden to show, even under the AOA, that the income would be allocated to Ireland. So the General Court held that the commission had to look at the substance. It had to look at what the Irish branches actually did. And the General Court furthermore held that all the important functions and decisions were taken in the United States, and these decisions were either taken by the head offices themselves that had branches in the United States, a branch or more, or by Apple Inc., a U.S. company, on behalf of the head offices. Either way, those functions did not happen in the branches, and so the branches could not be allocated the profit from all of that activity. And in any state aid case, the commission bears the burden of proof. So if the commission didn't prove its case, it loses. So the commission lost at the general court.
Okay, not so much because of the law or the way what they fought, but more the facts, as you say, that the reality was that these profits belonged somewhere else and they didn't belong in Ireland.
Exactly.
Okay, so we've got a big reversal of fortunes there.
Yes.
Apple's happy, Ireland's happy. The commission is probably quite peeved. So what happens next? Take us further along in the saga.
As we said, this is just the lower court decision. The commission appeals. Okay. And when you say it's a reversal of fortunes, it was quite an upset because it was viewed as being politically quite difficult for the EU courts to override such a large decision by the European Commission. And it was perceived that overturning such a significant decision by the Commission would not only embarrass the Commission, but undermine it in its state aid enforcement efforts. And so therefore, people basically thought, the EU courts are going to find some way to uphold this decision one way or another, even though the outcome was kind of crazy. But then the Court of Justice held with Ireland and Apple. But supporters of Ireland's view were still disappointed because they lost on the law and they felt like the general court decided the legal issue wrong. But those people who were disappointed that Ireland lost the legal issue weren't disappointed for long because soon after that case, there was a judgment in the Court of Justice, the highest court of Europe, in a different case. This case was Fiat Chrysler, another state aid case.
Okay.
And in Fiat, the Court of Justice said that the Commission cannot use external standards for establishing that a member state conferred state aid.
Oh, which would get back to the guidelines there, right? The AOA.
AOA.
That's right, yes. I've been listening. I've been paying attention.
Yes. So if you have been following along, right, what the holding of the Fiat case implies is that the Commission now can't use the AOA. It has to use Irish law. And Irish law, as Ireland contested all along, requires looking only at the branch and making sure that whatever actual activities the branch did was awarded income and was taxed.
Ouch for the Commission.
Right. So you have this situation where the Commission lost on the facts in the general court, and now you have a superior court decision from the highest court of the European Union saying, well, it should have lost on the law too. Okay? So the Apple representatives and the Irish representatives must have been very, very confident going in to the appeal that the Commission took from the general court's decision.
So, before we're going to have a short break now, give you a chance to grab a sip of water, and me too. We've talked a lot already, but we're going to talk about this decision now that just recently fell. So I'll take a short break now with Ruth, and then we'll be back to talk not only about the most recent decision in the case or in the saga, but also the broader implications after this short break.
Allow us to introduce you to the wealth of information found on the Max Planck Law website. Discover a range of events, from researcher-led presentations and reading groups to workshops and conferences, many of which are open to the public. Keep up to date with our news, explore the tangible impacts of our research, and peruse Perspectives, our online publication offering insightful articles on current legal issues. And of course, for those looking to pursue a PhD or postdoctoral research, you will find everything you need to know about our many academic opportunities. Visit our website today, law.mpg.de.
So, welcome back to the Lawcast. I'm joined today by Ruth Mason, and we've been discussing the Apple Ireland EU tax case and its ramifications. So, Ruth, we've talked a lot now about what happened in the previous few years that have led up to the most recent decision in September 2024 by the European Court of Justice, is that correct? Yep. Okay, so, and this is providing yet another twist here in the saga. Would you like to fill us in on what's happened just recently?
Yeah, good. So, so far we've said that there was this intervening case in Apple that says, okay, the Commission can't use external law, and the Court of Justice, highest court of Europe, gives two reasons for that. One is that the member states retain the power to define their taxes when they entered into the European Union. They still possess that. And so the Commission can't change domestic tax law. And then second, the Court of Justice just cites this principle of legality in taxation, which the court says is part of the legal order of the European Union. It's a general principle of EU law, and it says the taxpayer has to be able to foresee and calculate the amount of tax due.
Mm-hmm.
And you can see, right, if you start applying these, unwritten and as yet uninvented international standards retrospectively, as the commission tried to do in the Apple case, the taxpayer can't predict their taxes.
That's right. Okay.
Yeah.
So Apple and Ireland are feeling fairly confident, right?
They're definitely going to win this case.
Mm-hmm.
That's what I thought.
Yeah.
Then the appeal happens, and the case comes out last week. And so this was a big shock for everyone that Apple and Ireland lost at the Court of Justice. The Court of Justice, maybe misunderstanding the judgment below, said that the lower court, the general court, had held that Irish law in 1991 was the same standard as the AOA. It says that Irish law not only requires the arm's length standard, but that the general court had held that you can use the AOA to check the work of the Irish tax administration. And that's even though Irish law, Ireland contended, required only looking at the branches, only looking at what was actually happening in the branch. So the Court of Justice also held that the general court was wrong to conclude that the commission had applied this external standard, the AOA, the wrong way. The High Court now says that the commission had sufficiently proved that all the management of the intellectual property of Apple and the other important functions of the Apple group had actually happened in the Irish branches, that the commission had carried its burden of proof to show that those things had happened in the Irish branches.
Wow, right. Uh-huh.
Yeah, right. So
go on, please.
Right. Explain this to me.
Yeah.
So, what we know, what everyone living in reality knows, right, is that the management functions of Apple and all of Apple's important IP is managed from the United States. So it was a shock because the case seems to confirm that Apple is run out of Cork, Ireland, not Cupertino in the United States.
That's right, yeah. Because whenever I get an Apple product, it says designed in California, right, on there.
Right.
Made in China, designed in California. Nothing with Cork Island.
So that was one shock, is the distance between the reality that everyone, including non-tax experts, everyone with an iPhone in their pocket knows, which is that the profits of Apple are attributable to activities in the United States, somewhat to elsewhere, sales and so on,
Certainly.
but not to Ireland, of all places, right? And no offense to Ireland.
That's right. We love Ireland.
They're not running Apple. It was also a shock because everybody thought that after Fiat, the commission couldn't apply external standards at all. And so there was that misunderstanding by the Court of Justice where it said that the general court had held that Irish law was exactly the same as this OECD standard. That's not what the general court held, and that's a really significant misunderstanding by the higher court of what the lower court had held. And, what was most distressing about this case as a matter of law was that it seems to ratify an outcome that makes no sense. So Ireland now, contrary to its own law, has to tax profits that were earned in the United States. And this is so, even though there was a ruling by the highest court of Europe that says that Ireland's entitled to use its own domestic law to determine the profit in Ireland. And specifically, this ruling in Fiat says that the commission's not allowed to use standards other than domestic law to determine profits.
That's a doozy.
Yeah, so, this was a little bit difficult to accept. As an added tidbit, since the commission finished its investigation in this case and ordered the recovery, the tax law changed in the United States.
Okay.
So now that all those earnings that Apple was keeping offshore and was going to decide if and when, if ever, to repatriate, which was going to trigger tax, U.S. law changed, and all of that was repatriated as a matter of U.S. law and taxed.
Oh, dear. Okay. So that money is actually no longer in Ireland.
Apple's been taxed, and it was taxed by the right country on this income. And now the income is set to be taxed a second time by Ireland.
Oh, dearie me. Everyone wants a piece of the pie now. Okay. All right. So, I mean, sounds somewhat on shaky grounds, this whole proceeding, and there's uncertainty here about how the law's been applied, how the facts have been judged. Does this mean, though, I mean, you said that it's the highest court, it was on appeal of the highest court of Europe. Are there any avenues open now to Ireland or Apple to follow this procedure anymore, or is it now case closed?
Ireland and Apple have exhausted their options in the European courts. I don't know if there are any options available to them in Irish courts because it's a principle of state aid law that the national court determines the exact amount of recovery. So maybe now Apple can argue, hey, the U.S. taxed me, the recovery should be reduced. I'm not really sure that's a matter of Irish law. But I think what we can see in this case is that Apple was really hoisted by its own petard in this case. It has this clever tax plan to put its profits, its paper profits in these stateless companies, and its goal will be taxed neither by Ireland nor by the United States. And now it's in a position to be taxed by both.
Yeah, wow. As you say, the plan in the end backfired. Oh my gosh. Yeah, I was reading in the on The Guardian, there was an editorial piece about this and about what Ireland should do with their windfall. And I thought one was to give every citizen €2,500, which was divided by, what was it, 14 billion divided by the 5 million citizens, to build a high-speed rail network. Or the funniest one, though, I thought, was to immediately buy 16 million iPhones and apologise profusely to people.
I think a prudent thing to do might be to invest in some Apple stock. Ireland's done okay. Apple's done okay by Ireland so far, and vice versa. I mean, I don't think Apple has really any cause to be upset with Ireland. Ireland, did its best. It put forward the right arguments in this case, and those arguments were not accepted.
Yeah. Okay. Well, we'll have to see then what happens now after the case, at least with Ireland, and with the US, and with Apple. But I mean, we've talked now a lot about this case, and you've done a brilliant job explaining it, breaking it down, because it's certainly no easy feat. There's been a lot that's gone on, and it's complex. But what does this mean now? Because we now have, as you say, laws applied retroactively. We have guidelines now kind of imposed into country or member state law by the EU. I mean, what does this mean for multinational corporations operating in Europe?
I mean, that is a very good question that I'm not yet prepared to answer. I mean, I think we're going to kind of be figuring out what the implications are from this case for weeks, months, maybe years. The immediate implications are not too concerning, mostly because the law has changed. So, Apple wouldn't be able to do what it did in this case in quite the same way now. And member states have agreed to, at least the European member states have agreed to apply a minimum corporate tax, which frustrates Apple's goal to have stateless income that's not taxed anywhere. In terms of, retroactivity and what's the standard and how does fiat play with Apple, how do we reconcile these two court decisions? Again, it's not clear because the Court of Justice neither applied nor distinguished fiat in Apple. So it didn't tell us what the status is of fiat after Apple. Fiat says you must use domestic law, you can't use anything external, but Apple approves the use of something external without mentioning fiat. So my guess is that because fiat is so very clear on the issue, the commission can't use external standards anymore, but the commission could always cite to Apple. So I don't know.
No, fair enough. I guess a knock-on question is that there's few things that are very sacrosanct to the EU member states, and one of those is definitely their own tax policy. This has been something that's traditionally been absolutely off limits to get involved in a nation state's tax policy, like it's military. These are things that the EU doesn't do. It seems, though, that this is no longer off limits.
It really depends on whether fiat or Apple prevails, because what you have in Apple is essentially the commission saying, hey, Ireland, your standard, and this is what the General Court held, your standard is, I can't remember the exact wording, but something like essentially similar to the external standard. Therefore, the commission can use the external standard. But the notion that because your law is similar to some non-law produced by an international organization is not going to let the member state get comfortable that it is the author of its own law and that its voters are the authors of its own tax law. So, I mean, that's something that the Commission and Court of Justice are going to have to work out, and the sooner the better.
Absolutely, that's right. Yeah, well, we'll have to, as you say, there's obviously still things to be sorted out from this case. The ramifications are deep, and we'll have to see, where we are within the next year, 2 years, 3 years down the track. I wanted to know, though, why you think, maybe you can't say why, or don't know why, but there were plenty of companies running this tax route of having a stateless company in Ireland. I mean, Apple was definitely not the only one. I think you can look at most large companies had this going on at the time, or not most, but a lot of large companies had this going on. Do you think that there was a particular reason why Apple was singled out?
Well, so the answer to that question depends on who you ask. So if you ask politicians in my government, the answer is discrimination by the Commission against U.S. companies. That's not my answer. When this case first came out, I pointed out in response to these charges that the Commission was discriminating against U.S. companies. I actually went through each of these cases where the Commission was bringing a case involving a U.S. multinational. And it's true, the early cases were all against U.S. multinationals, not against European companies. That changed over time. And I was able to track through the likely source of each of these cases, which was something that happened in the public sphere. So with Apple, there were investigations by the U.S. Senate of Apple's tax plan, and an Apple executive testified to the Senate that Apple negotiated its tax rate with Ireland. Yes.
And that kind of raised the ire or the hackles at the Commission when they heard that.
Certainly the suspicion at a minimum, and rightly so. So Apple ended up withdrawing that testimony, but not before, as you say, raising the suspicion of the Commission, which then sent letters saying, well, we need to know more. The other early state aid cases were similar. There were similar investigations by the UK Public Accounts Committee, and so all this public information led to the cases. And I mean, I personally don't think there's anything wrong with the Commission targeting Apple as part of its policy to target high-value cases. I don't think there's anything wrong with the Commission targeting a particular U.S. company, as long as it's not targeting only U.S. companies in a discriminatory fashion. What is problematic is the Commission using 3 different mutually inconsistent theories of law in its final decision against Apple. And then in its argument before the General Court, the Commission changes its legal theory again and brings a new theory for how Ireland confers state aid on Apple. And then before the Court of Justice, the Commission argues that it didn't assign income to Ireland by default, but instead had affirmatively proved that various valuable Apple IP functions were performed by the Irish branches. I mean, that was not true. It didn't prove that. And even if the Commission had tried to prove it, it would have failed because that's not true in reality, right?
No, as you say, it's taking place in America, in the US.
And worst of all, the Commission knows that very well. The Commission knows where these functions were performed, and so did the General Court, which is what it found. And also the Court of Justice knows that those functions were performed in the United States, too. Everybody knows where the important value-creating activities of Apple happen. Everybody knows that they happen in Cupertino, not Cork. But nevertheless, right, you get the Court of Justice siding with the Commission on this rather absurd claim that it had proven that Cork runs major strategy for Apple. And, so there's nothing wrong with the Commission targeting Apple or with the Commission targeting a small business-friendly, low-tax member state like Ireland, but there is a fundamental fairness issue when the Commission pushes and the Court of Justice simply accepts views that fly in the face of reality. So, that's my issue with the case.
Yeah, certainly, I understand. Well, if we were then to say, to move beyond the law, I mean, politics, where you just kind of touched on it there with the Commission and politics plays a big role here as well. And if we're to jump over to your side of the pond, dating back, I looked here, this was in 2016 when the very first finding took place there from the Commission. With Barack Obama, he was saying that this sets an unfortunate international tax precedent. And he went on to suggest that should Brussels become a supranational tax authority, this cause ripples in the water between the US and the EU. A lot changes in politics in a year. And even we've had longer now, and things could change even more in the upcoming elections. What, if anything, could be the economic repercussions and potential responses from the US to this decision?
Yeah, so, the Obama administration and the Trump administration did not agree on much, but this is an area where they agreed. There was bipartisan opposition to the Commission's attempt here in Apple to lay European hands on what was considered U.S. income. I do think that there's a risk that the more the Commission meddles and tries to change member state tax law, the more trouble it's going to get into. The Commission is not a tax expert. It does require expertise, significant and deep expertise to run a tax system, and that those functions are by treaty now still with the member states, and that they should stay there until the member states themselves decide to confer those powers on the Commission. And, even looking at this from purely a European perspective, there's plenty of reason for concern. In addition to all of the strange arguments that I just described, there's the unwillingness on the part of the Court of Justice to apply its own precedent from fiat in this case. The failure to apply the fiat precedent resulted in an outcome that was contrary to economic substance and contrary to state aid law, as announced in fiat. And so the actions of not just the Commission, but also the Court of Justice here call into question both of those institutions' commitment to the rule of law, by my lights. Mm-hmm. And so a message that non-EU countries like the United States could take from this case is that EU member states like Ireland can help your companies avoid your tax as long as they split the loot with an EU country.
Mm-hmm. Okay.
And the Commission and the Court of Justice will ratify this totally non-substantive result that Apple fashioned here. Because after all, at the end of the day, Apple actually comes out ahead because it would still rather be taxed by Ireland, which has a 12.5% rate, than by the United States, which at that time had a 35% rate. So Apple still wins. Ireland wins, but, footnote here, Apple doesn't really lose. So if the message that non-EU countries draw from this is that their companies can't get a fair shake in Europe because the institutions are going to deviate from law to achieve a politically desirable outcome. First of all, companies may decide to invest elsewhere, but also countries may not want to cooperate in international tax plans if those reforms would include EU institutions like the Commission and the Court of Justice.
Well, thank you so much, Ruth, for the answer there. I think we have to wrap it up for now.
Yep.
There's just so much to talk about, and you've done a valiant effort helping us through the long saga. Maybe still no end in sight, but definitely movement on the tracks, and we'll see where it all heads next. So thank you so much for taking the time to join us on the podcast today.
Thanks so much, Chris.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.